We are right here at the Sarova Stanley Hotel, and we're going to be listening in on a debate by the stakeholders on the Data Protection Bill. Let's listen in.
Article 19 addresses the retention of data. It's a general statement of the principle of data should only be held for as long as it's necessary. But when it comes to the way personal data belonging to children is treated, we're of the opinion that we should add an extra obligation for schools, because the bill does limit the collection to schools and for purposes to do education. But the schools, once they collect this information, personal information, including even the record of the child while they're in that school, it should be either sealed. If it's a criminal record, it should be sealed or deleted after some time. This is to prevent things that children did in primary school and secondary school affecting their future life. So clause 29 needs a little bit more of attention. Then consent is a very recurrent theme in this bill. We like that it's a requirement now for any collection and for any processing to take place. You have to seek the consent of the data subject. However, we don't have direction on what this consent looks like. So maybe let's have direction on what effective or what valid consent should look like. Things like voluntary, things like consent being an affirmative action, not an opt-out system, an opt-in system. So there's that as well. And then on the application of the bill, maybe this bill could apply retrospectively, so that we don't limit the bill to data collection, but it applies to data processing generally. So that those who have personal information as we speak before the commencement of this act will also fall under this law. And then maybe what we can do is have an enforcement date where we give all the data agencies maybe 3 months from the coming into force of the act to comply. And then after that, the Commission has the power to fine and even to issue the notices, as we were saying. The Commission as well, going back to the Commission, the more we think about it, the more it's a little bit confusing, because some aspects of data protection are super specialized. So perhaps the question we need to ask at this point is whether the Commission has the power to even set up a department within itself and employ people who are have a specialty in some fields, so that we now give the Commission power to give directions and give even regulations and legal opinions, because some of these things, yes, we can state the principle generally in the bill, but when it comes to application, we need more details, so that agencies don't find them in a funny position where they always have to refer back to the Commission. Oh, should we do this? Should we do that? Yeah. And then on the obligations, where we have given a data agency an obligation, we should match it with a complaint mechanism. So where there's an obligation, for example, to notify, what is the remedy that we give to the data subject where that notification has not been done? So that there's more, as my colleague was saying, there's a better relationship between the Commission, the data subject, and the data agency. Yeah? So I don't know whether it has...
Thank you very much. I just want to highlight just a bit of statistics in terms of just how much information is being collected by who.
You're also from Cape Town?
Yes.
Okay.
The register of births, all the people who have been born in Kenya since they started recording in the 1900s. Mobile subscriptions now at 42.8 million. The last census captured data of 39 million Kenyans. The IPRS has more than 35 million records. WhatsApp is being used by 12 million Kenyans. YouTube, 8 million. Facebook, another 6 million. eCitizen, 2 million. There are different agencies collecting personal information. They are not just government, they are the private sector. And also individuals, and some of them are multinationals outside the country. And when we are developing legislation, we have to put all this into context, that it is not just the Ministry of Interior. We are collecting information about citizens of Kenya and also foreigners. We had almost 1.6 million tourists who crossed the borders last year alone. So we must start seeing that into perspective. Just a few things to highlight, some of them have already been mentioned, is that we must, from the get-go, encourage and require privacy by design. That this bill, the objective is to protect the right to privacy, and that must be the running theme throughout the bill. It cannot be about giving exemptions. It must first and foremost be about privacy. And secondly, that the questions of risk, because of the amount of data that is being collected, it's important to have a provision on risk in terms of what these key institutions must be required to do some risk assessment of the information that they are collecting and what is exposure of that information to threats. We have a new cybercrime law, and the people in the industry will confirm that there are a number of attacks. What is usually targeted is that private information. So if that institution does not have a framework to protect the information, then there could be some challenges. The other aspect, and has been highlighted, is the aspect of the commercial use of data. A number of the services that we're using today are primarily based on trading with the data that is used. You have your Facebook page, Facebook uses it to target advertisements. We have 300,000 Kenyans using Uber. We have so many using Google Maps. That information is being used to trade. And how can we safeguard the rights of those individual users whose information is being used for commercial purposes? So there must be some restrictions and greater responsibility on whether it's public or private institutions that are collecting data of many citizens. I think I'll stop there. I think data, yes, the aspect of transborder must also focus on the data subject, that we have people using airlines across the world. We are hosting information on the cloud. 19.8 million registered voters. Their information could not be accessed during the presidential petition. And how do we ensure that critical information regarding the country is kept within Kenya? The register of voters could not be accessed. How do we ensure that even as we embrace cloud services and other technologies, we're able to secure critical information that relates to Kenyans? So I think that's something that also we must put into consideration. The other, I think, thing to mention is that in terms of the responsibilities or the capacity of the commission, that one critical aspect should be civic awareness or public education on what my good friend from Estonia was talking about, cyber hygiene. How can we encourage people to know more about how to secure their private information, and what responsibility are we giving to institutions that are collecting this information to educate their users and tell them about their rights and what information they are collecting. It cannot be that you are just asked, as a notice is given and you just have to input. There must be a greater responsibility on these institutions, and also relating to the fines, that they must also be, you must take into consideration where offenses are committed by legal persons, if they are companies and so on, so that we ensure that this information is kept secure. It's important to note that even government services are being handled by third parties. iTax, for example, is being managed by Tata. IBC was being managed by Safran, which shows that even when you put responsibility on public agencies, there is data that is also being handled by third parties. Even when you have given a consent to IBC, they have given that information to somebody else. So we must also see how the law can address situations like that. Thank you.
Fantastic. I think those are very important submissions so far. Even shops. I know that when even on our broadband buy something, they said, "Do you want your receipt to be sent by email?" And I thought that was such a good idea, isn't it? I'm like, yeah, actually I'll lose my receipt, send it by email, but what comes after that is not just a receipt. It is promotions, it is also, I'm like, I just wanted my receipt, and now I'm bombarded with every offer that shop in the United States. This weekend, come. I'm like, I don't even know where I live. So those are very important submissions. I think there was a hand there.
Okay.
Please give the mic.
So, in addition, what we'd like to look at is the committee that is selected should first of all immediately come up with standards and standardization. Then it becomes a clear guideline for whichever agency, both government and private, what they need to meet first before they are allowed to collect data. So those are very critical elements.
Just a clear, are you proposing that we have a committee, or is it the authority that we're talking about here? Just so that we're sure.
The regulator.
The regulator, the authority,
yes.
Okay, fine.
And these standards would apply to different subsectors and different aspects of data. And then secondly is where the data agency is a victim. So the assumption that the data collection, the moments when there's a deliberate effort by an external entity to reveal data, and despite all that you have met and all that you have put in place, you're still the victim of an attack. So in this case, then the data agency is not the criminal, but the victim. So we should then work around how then do we move around. The aspects of it in the Cybercrimes Act, I believe it should also be captured in this section.
I want to provoke some debate, if I can, on this bill. When you look at the limitations, that's clause 6 of the bill, it talks about instances where the right to privacy, because that's the import of this bill. The import of this bill is to protect your privacy. It says that there are two issues there I want to flag out and provoke some debate on. It says that there could be limitation in public interest. You sit back and ask yourself, what is public interest? Who defines public interest? The other day, I'm very sure a lot of us are following this after the January 30th. Some reason the government decides that in public interest, you withdraw security for members of parliament who belong to a certain political grouping. In public interest, you shut TV stations for 10 days. So who defines what is public interest? And alongside the same line, there's something called national security. What is it? What amounts to national security, to the extent that now your data can be accessed by whoever and be used for whatever. If this bill passes the way it is in terms of clause 6 on limitation, then all the other things that we'll have debated and done will come to naught. Yeah? Because somebody can just flag and say public interest. There's no definition for it. Or national security, there's no definition for it. And lastly, and it's what he has just said, this bill goes on and on and on about data collection agencies. There is no provision in this bill on registration. What are the standards of the data collection agencies? Because, one, I come from a principle that says big is big and small is small. There are no in-betweens. We must define what these agencies are and what standards they must be required to meet. Before then, they can be allowed to collect data. And I'm very happy that Safaricom is here. I would have expected that IBC would be at the front row. I would have expected that the registrar of banks would be here, because these people collect data every day. Yeah. So let's look at those issues. Thank you.
Thank you, Senator. I think those are very valid inputs. We did invite all the public bodies. They did give some submissions, and we did agree that as government to government we will consult in another forum, but they did provide some submissions as well. But point taken, both the feedback from the private sector and the rest who are in this room is that public bodies must be subjected to this law, and they will be. Good. Any other? Great.
In as much as we are looking at data privacy concerns of individuals, and so to speak from a banking perspective, our customers, we feel that the bill should be able to accommodate sharing of data pertaining to customer information specific to the industry. So it shouldn't be limited to what we currently have, prudential guidelines of CBK, which guide on how you're going to share credit information for our various customers, because it's very important in how you sort of monitor the performance of a customer's loan balance sheet. Another aspect which we think is really not properly addressed is how customer data regarding due diligence in pursuit for anti-money laundering and CFT provisions, which are also catered for in the prudential guidelines, but are not factored in this particular bill, where we are not seeing a clarity on the same. We would also want to the committee to look at when dealing with fraud prevention and investigation of fraudulent activities, there would be need to have data shared. And this data could be from machine to machine. And I had a couple of speakers before talking about how data generated by machine or AI is going to be accommodated in this particular bill. So we would like that factored and looked at from this bill.
As a matter of fact, being a trained data scientist, I'm unable to provide my services to the industry because of lack of this law, because of the era of discrepancies and lack of laws in our land. It brings a very delicate situation. So, and I think one of the things that we need to acknowledge, perhaps in the training of our data science career, the first course that we do is on data protection. So it's very important to take that in cognizance to see that we need to build skills, we need to retool the relevant professions in our industry. But then, with the lack of this law in place, then that curriculum will not be complete. So this is how important it is for us in academia. So secondly, I'd like to take cognizance of the fact that there's some, what you call terminologies here. So there's a mix-up of terminologies when drafting this. And I'd like to just put a particular context in terms of three key fundamental principles that govern any conversations around data. We have three levels. So you have owners, you have users, and you have brokers. Yeah, so it will be important to get those key underlying principles and coalesce any other evolving guidelines around those, so at least to avoid a mix-up in terms of what implications is going to occur where. And then, in terms of the emerging technologies, we see a scenario that's emerging. Of course, we are learning a lot from what Facebook and the Congress, what they're undergoing. We are seeing the laws being reconstituted to accommodate areas of oversight. We need to take that as an advantage that we are sitting in this, we are sitting here, we are drafting these laws. We need to borrow a lot from what's happening there. You can be able to see pre-2012, a lot of these technologies have been available from 2012 onwards. How do we protect the data owners from exploitation? So in that regard, I'd like to draw attention to a particular theme that I see recurring in this draft, which is we are focusing more on the first line data, yeah, which is what you call data. But there is in data science, our main focus is on metadata. So metadata is a story around data. So I see that accommodated in what we call processing of data. But processing of data is also limiting because it has it means just the processing which you can do in different levels. You can look at graphs to see the trends. But there's more processing that we say we look at behavioral traits and how people behave around certain circumstances and make conclusions. And that's what the business of Cambridge Analytica is. It's around the metadata. So we may not even have use for the data that is collected and stored, but just looking at, for example, location intelligence and how you move around, we're able to predict patterns of what you're going to do next. So I think it's important to put some particular attention to that, so at least we govern. And I see the loophole lying in clause 31, where, because you know this is data transfer of regional data. So if you're able to put the competencies you have within this country in relation to what our vendors are, and vendors for this case are the Microsoft, the Oracles, they're quite advanced in this technology. So when we expose our data there, they're storing that data on our behalf, there are more insights around us, which is not covered here, and they can use that information, for instance, to create what we call advisory services. So these advisory services could be in any area, for example, in credit scoring. Yeah, so whenever we get for a Eurobond and we need our score, they can advise the Moody's to rate the country differently. We also see advisory services in the area of intelligence and security. Yeah, I think there are many use cases which are coming out from even the devices we wear on our, which we call the Fitbit, the fitness devices. Yeah, there's a use case where a scientist was able to track give location of the US Marine in Afghanistan. And that information could be availed to the Al-Shabaab there. Yeah, so it will be important to see how this data is stored and collected, so at least to protect what you call the interest of this country. Yeah, so I think we've met most submissions from under the KickNet umbrella, but I think we can continue engaging much more in detail to be able to look at the granular issues that this document evokes.
Thank you very much. Madam Chair, I wanted to respond to the Senator's provocation on public interest. And just to wonder why after so many years of this use of public interest, this word has never been defined. So it looks like those unfortunate words, we need them, but we don't acknowledge them, but we apply them, when it becomes absolutely necessary. Because I think what has happened is this word has been left to the definition in the judiciary. And I was thinking of a situation, for example, if there was a section of the population that carried a deadly disease, for example, it might become necessary to disclose that data. Now, I don't know whether to say that in national for national security, or a section of population had something, maybe like mass hysteria or something, things that are unforeseen. So I think because of the dynamic nature of unforeseen events, this word is, we use it conveniently, but we don't embrace it fully because we don't want to define it and lock ourselves in. So I don't know, but we stand to be guided on the use of that particular word. Then he spoke about the issue of the lack of framework for registration of the data processors and controllers, and we cannot agree more because we are a country in sub-Saharan Africa. This is a very abstract issue. Information is stored so haphazardly sometimes. This is why the situations were being cited about papers being used to wrap meat and they have personal data. So we bring in an inanimate subject and not provide guidance on issues of risk assessment, audits, information security, all that kind of a thing. In fact, I think one of the key things that should be included here is the formal recognition of the data protection officer. The data protection officer is a critical player. It also really announces formally
the entry of a certain specialty. I think that might also give comfort to the data scientists and others, because without these key players in this ecosystem, it becomes difficult because it's a technical issue that is under implementation. Then on to my third and last point, and this really just affects the implementation of the bill. I think it will be very important to think around the issue of the roadmap in terms of the implementation of this law, because unlike many other laws that are passed and they become effective immediately, if this was to happen, if implementation of this law was to be immediate, I think we would be up to fail immediately. There needs to be time given for the establishment of the authority that would handle the issue and to build its own capacity. There would also be time given for the necessary skills and expertise to be built in the industry. Already we are aware that globally, there's a shortage of data protection officers globally. In fact, in some jurisdictions like New Zealand, they have even put in the law that you can be a data protection officer working anywhere in the world. The reason you would open that up is because you lack the capacity from within. So we do need to build that critical expertise here and get the certifications. Then the other component that my colleague mentioned about building the knowledge and sensitization for us, the consumers, so that once those three critical ingredients interact for maybe 2 years, 3 years, people and businesses, then in fairness, we can then say the law has now kicked in and it's now going to be implemented going forward. Thank you.
Thank you very much. It's something that as this committee will take on and find and create maybe a platform again for us to be able to define these things. I would like to recognize, before I give the next speakers, the arrival of one of our committee members, Senator Bogisio. Senator Bogisio actually was a Minister for Information and Technology for a long time, as you all know, and very, very important key person in this committee. He comes with a lot of experience in this sector, and he's also very keen and passionate about this sector. He's actually supposed to be on travel, but has detoured so that he can come and say hello and actually just make sure that we're doing what we said we were doing. Karibu, Senator, and please introduce yourself, and then we'll continue.
Thank you very much, Chair, and all our stakeholders. This is Samuel Bogisio, a member of the committee, Senator from West Pokot. And sorry, I wasn't with you in the beginning and probably won't be because of the travel plans. I just wanted to come back and look at what progress we've made and ask that we take this matter up very seriously as a country, that you'll help us quite a lot as a committee, that you build a data protection law that is going to stand the test of the current times and the times of the future, so that we together can do this. So I am with you, except that I'm traveling for today. But I just want to confirm that this is a matter that has been very close to me, and I'm particularly interested in making sure that what we have started in ICT is not destroyed because we don't have a correct and proper data protection, so that we can move this country to fast lane in terms of ICT development. So I want to say thank you, because I have just come to say hello to all of you. I hope that may not be here. I can still say that because we're going to have these meetings continuously, we're going to have other sessions to meet, so that it's not the only one. So please give all you have. Make sure you make your contributions. We also put to do our best, and I hope we can move in this direction together. So thank you very much.
Asante sana, Senator Bogisio. So we'll take a few more. We'll take a few more submissions so that it goes that way again.
Thank you very much, Madam Deputy Chair. I want to respond to Senator Wambua's challenge in terms of what is public interest, what is national interest. And Estonia being a member of the European Union, of course Estonia has to have its laws all complying with European Union requirements. Equally, Estonia has a not so friendly neighbor in the name of Russia. And so when it comes to issues to do with a national interest,
Is Russia anybody's friend?
Possibly Trump's friend. These are areas in which, of course, in Estonia taken very seriously. And Estonia itself, having suffered a cybersecurity attack in the year 2007, and having established, together with NATO Center of Cybersecurity Excellence in Tallinn the following year. So these are some of the things that Estonia has looked through. And indeed, when it comes to accessing anybody's private data or private information, it is regulated. And so there is nobody's gut feeling that will determine whether access to private data is in public interest or national interest, but it actually goes through the court process. And so the efficiency of court processes, of course, is then a requirement when it comes to being able to then respond to matters swiftly. Equally, what is important is that the lawyers and the judges are well versed with cybersecurity laws, which is again another step. By the way, Estonia does offer a lot of scholarships in aspects of cybersecurity, including cybersecurity law. And so then it further then comes into the aspect of what kind of regulations would need to be there in order for the data collection agencies. And most of the time when you mention data collection agencies, you're talking of the things that are there currently, which are collection of dates, date of birth, issues to do with health records, etc. But in modern day, most of the data collection agencies are in the virtual reality world. They are things that are of artificial intelligence. They are things that are mentioned here, the Google Maps of this world, who collect data without you having necessarily given consent or you being able to regulate or control that. So a lot of the data collection agencies indeed are not the ones that you have in mind currently. If you'd like to have a look, the website is actually quite simple. R for Romeo, I for India, A for Alpha, .E for Echo, E for Echo, ria.ee. That is the Estonian information agency, Romeo India Alpha.ee. ria.ee. And it has the English version as well, and it actually has a lot of the information that relates to how Estonia processes and protects its data. It's the authority that is in charge of all the cyber security information and things of that nature. So do have a look, but it also stipulates what kind of security measures need to be put in place in all the Estonian agencies and databases that hold data. And these have to do with the physical structures, the security structures, the necessary firewalls, etc., etc. And then, of course, in Estonia, a lot of the data is timestamp hash separated, which is a form of blockchain. And indeed, in order to have proper protection in place, some of the cybersecurity measures need to be implemented, including things to do with blockchain. But then, of course, the issue comes of what kind of databases. Anyway, so this is my brief response. Thank you.
Thank you very much. As you can see, Estonia definitely is an innovator in a lot of these things and is quite ahead. I was just telling the Honorary Consul that when I was in Germany and I thought we were benchmarking with Germany, and they told us, no, it's Estonia, we're also going there. So it was very interesting to note that Estonia is really providing leadership in innovations around data and e-commerce and all sorts of things, and digitalization and all sorts of things. So thank you very much, Honorary Consul. We're happy to have you here, and we're happy to be engaging with you. Yeah, okay. MasterCard?
MasterCard, thank you. I disagree that on occasions it's a term that can be misused or is very broad, but rather it's something that a bill such as this should absolutely have at the heart of it. And a bill such as this should absolutely seek to protect. And we would suggest that that protection shouldn't come in the forms of strict requirements for a tick box consent or strict restrictions on moving data, but on perhaps more sophisticated, if you will, restrictions and requirements for individuals to consider the rights and interests of data subjects and of the public at whole when they process personal information. Obviously, in our written submissions, we'll go into more detail on the specific clauses, the definition of personal data, allowing for anonymization, pseudonymization, for using bases such as having solid contractual arrangements in place between people who share personal data as a basis for processing, rather than simply consent, something that processors and controllers will be held to should they step outside of the bounds of it, or alternatively binding corporate rules, or real requirements to balance the rights of individuals. Because as I listen around the room, I get the sense, and you'll all forgive me if I've misunderstood, but I get the sense that it really is that accountability and that real protection of people's interests that is at the heart of everyone's concerns, which is why we talk so much about having a data protection officer, someone in the company, on the ground, who can assess transactions and make decisions, having a strong commission who can uphold standards. And what I'd suggest, and we'd suggest, is that perhaps having these alternative requirements in the bill, rather than some of the stricter requirements, might actually protect some of those rights and allow the public interest and the subject's interest really to be taken account of by everybody who touches that information. And as a very final point, I've heard an awful lot about direct marketing today, and I understand completely, because direct marketing is extremely tiresome and bothersome when you hand in your information for one purpose, and it's suddenly you get calls, you get messages, you get emails. I wonder if perhaps that's the word commercial in clause 21 is looking at that kind of use of information. And I wonder therefore if perhaps the regulation of direct marketing specifically, as it appears in many other legislations, particularly in Europe in the E-Privacy Directive and in many other data protection acts around the world, might be something that would be beneficial, where consent is absolutely required and must be recorded to send a direct marketing message, rather than some of the broader prohibitions and requirements on personal data. Thank you.
Thank you very much. Anyone else? I think there's a hand to come to.
Greetings. Mine is on Article 31, to emphasize what others have said. I'd like to emphasize that we can actually back up data abroad without compromising on the clauses here, especially for data that is held by government institutions. And there's been a persistent argument that this will affect cloud computing. But all the major players have technologies which can be locally set up in Kenya. Also, there's the very big matter of employment. If we compromise on this, we'll be denying our young people work. For example, I was telling the Senator Mutua, like Konza City, what's the point of setting up a mega city and nobody's coming to set up data centers there? And finally, if data is transferred, because what this law does, as I understood at the internet meeting, is that it limits data being transferred to nations which don't have laws that don't protect data. It doesn't forbid. So if those nations have laws to protect data, we can transfer it. But we also want to limit handling of data by foreign agents, especially government data. As we saw last year, there was security official agencies getting involved with foreigners and deporting them. We're guiding them to ensure they go as much as possible to avoid
involving parties that will cause national security agencies to get involved.
I think there's a balance that needs to be struck between the freedom to trade and cross-border flow of, data, and perhaps what you're mentioning around creating jobs and making sure that we're not protectionist, but at the same time, perhaps we're also protecting our data both in national interest. And is that what it is, or am I getting it wrong?
Let me explain.
Okay.
One thing about moving data locally
Yeah.
is that it actually protects data. Performance. There's a clause on the performances that 1C talks about the transfer is necessary for the performance or conclusion of a contract. Case in point, and we have Safaricom here.
Yeah.
Why did they move the M-Pesa servers here?
No, I hear you. I'm just saying that there were contrary concerns earlier on. I don't know if I just heard it wrong, that the bill may be restricting free flow of data and therefore may have maybe a negative or perhaps an unintended consequence on cross-border commerce and cross-border trade. That was some concern I heard about that. So I'm just trying to make sure that we understand where then there's also this other submission around the need to have data hosted here because there are benefits to that, and therefore vis-a-vis what was earlier. So that's what I'm trying to wrap my head around.
For example, I was at the Kick meeting.
Yes.
As I said, they actually helped some of us understand, as long as there are laws out there,
yeah,
like the ones we are now setting up,
right,
this does not ban the transfer of data. However, now talking from a performance point also,
right,
having data locally improves performance. And secondly, is if judges want to know who is administering the system, you can't tell them the administrators are somewhere in Ireland.
So would you rather, I'm just trying to understand so that even as we make our, as we put this feedback into the bill, we want to be sure that from the point of view of what you've discussed in your stakeholder submissions, is that it would be beneficial. Also, again, the question around what is of national interest, what would create national growth, and in those cases, is that what am I hearing right?
Yes, we need to specify in particular.
Okay.
Data gathered by public bodies. It can also be backed up abroad, but there must be local instances, especially if there's a legal dispute, and our judiciary wants to interrogate the handlers of this data.
So the jurisdiction then becomes okay.
I think what you're trying to say, the clause is explicit, clause 31, that any agency shall not transfer personal data of a data subject outside the territory of the Republic of Kenya. Now, there are conditional clauses down there. And I hear you are speaking to the sovereignty of data.
Yes.
Yeah? So that if the data is Kenyan, let's for lack of a better one, if the data is Kenyan, then the first port of call for that data in terms of where it resides is Kenya. Whether you back it up, whatever you want to back it up, that's a different conversation. But we should have access to that data here. And I know, if I'm not wrong, where maybe he's talking about the judiciary. We had this case in the presidential petition, where there was need for access to servers, and the people who were keeping the data were asleep. So we could not access that data. To date, I'm not sure they've been woken up. If they are, we have not been told. But it would have been a different story if we had unlimited and easy access to our own data stored in our own jurisdiction. And so, yes, but if you look at C, personally, I have a problem with that C. It's very loosely stated. Because what is this conclusion of a contract between an agency and a third party?
Yes.
I mean, these are the things that I'm talking about, where you have a very nice bill, then you give provisions there that would have, I don't know, it's our debate, you know. It's our bill, all of us. It's not ours, it's our bill.
Fantastic. I think we've understood. We will definitely make sure that there's that provision. Yes.
Yes. Perhaps even for the 31A, where we say you can transfer it to another country if that country has a legal framework that is adequate. In fact, the word is adequate measures. Perhaps that's not how we should approach it, because how do you then decide? Do we refer back to the Commission to always advise us, okay, does this country, does it have adequate measures? Perhaps what we should require is that any data agency, wherever you are found, if you're going to process data that concerns people who are in Kenya, then this is what you need to do, full stop. So they are all uniform to one standard, which is the consent standard, which is the obligation, the duty to notify standard, that you have to store it in a certain way and you have to notify the Commission if there's a breach. So maybe that's how we should approach it. On the thing with C, and I agree it's a running thing in the bill, is writing subjectivity in the bill is really dangerous. So not even here, if there are some clauses, in the exemptions clauses, for example, where it said where consent may be prejudicial to the performance of a contract, or it may not serve the purpose. So we are transferring this duty to the data agency, and you'll see in our memorandum we've actually proposed that those clauses be reconsidered, so that we don't have a situation where it's the data agency who is the judge and the jury. So this is the standard, and that will also help with our public interest debate again. You see, we don't need to have the word public interest there, and this is why. In the exceptions, you already said that if it's in accordance with the law. It is the law that gives the power, for example, to disclose health information in certain circumstances. Like, for example, in the case of an outbreak, then there's a law that empowers the CAS to disclose information. So then why do you need to have public interest in there? Because it's not even, I'm not very afraid of the public authorities at this point. I'm also afraid of thousands of data agencies who are going to interpret public interest, prejudice, contractual obligations in a million different ways, and you're never going to be able to reconcile all this. So let's just look through the bill with that eye of, is this objective enough? Is it a test that's objective enough? And then remove public interest, remove even national security. What is national security? And we had this debate again with the security laws amendments, where in the end they had to define, this is what national security amounts to. But again, if you have a provision that takes care of the prevention, investigation, and punishment of a crime, you realize it takes care of even national security concerns, because anything that touches on national security is more or less likely to end up being a crime. So if you've allowed police officers to limit a certain right, if you have limited a certain right for investigation and prosecution of a crime, then you don't need to have these generally worded clauses. And then with the exceptions, be specific. What are you exempting? With the data protection, there's so many rights. Is it the disclosure that you don't want someone to access that information? Or are you saying that because this is a national security concern, you don't even need to keep it private? That's not, I don't believe that's the intent of the Act. If it was an access to information legislation, that would make a lot of sense. But this is data protection. So are we telling police officers that where you've arrested someone, you don't need to keep their private information private? I don't believe that's what we're saying. So in the exceptions, let's not have a general exception clause. Let's go when we're saying rights of data subjects. For example, right to access your information, then limit that right, because we understand if I'm under investigation, then I shouldn't be able to access. But then don't limit the right to having my data secured to the highest standard, the right not to disclose this information to other people. Yes.
I'd just like to add my voice to this conversation regarding the limitation. And First, I'd like to redirect our minds back to 1948, Universal Declaration on Human Rights. And as a human rights lawyer, which has an idea now, is important to remind us of Article 12 of UDHR, which says, and I read, no one shall be subject to arbitrary interference with his privacy, family, home, or correspondence, not to attacks upon his honor and reputation. Everyone has a right to the protection of the law against such interference and attacks. Then, in 2010, August 27, Kenyans come together with the new constitution, and one of the things they say, in Article 31, every person has a right to privacy, which includes the right not to have their person, home, or property searched, their possessions seized, information relating to their family or private affairs unnecessarily required or revealed, or the privacy of the communication infringed. I think we need to start from there, that human rights, first of all, are inalienable. They are inherent in us because we are human beings. And these are things which we should not be discussing how to take them away, but we should be discussing how to secure them so that they can be enjoyed. You can only enjoy rights when you have them, not when they're taken away. And this goes to the discussion on the limitations. Because if you look, for example, and I will take us to clause 3 and clause 6. The Constitution is very clear about granting the right to privacy. And these two provisions really diminish, in fact, they take away the entire Article 31. The purpose of limitations is not to take away the right. The purpose of limitation must be very specific and targeted to a specific purpose. And Article 24, again, of the Constitution is very clear on the instances where rights can be limited. And that standard clearly has not been applied to these two provisions. When we speak about national security, prevention of crime, well and good, everybody needs to be protected from crime. But even criminals have rights, or suspects of criminal offenses have rights. And then it brings us to the question, and had been mentioned by the counsel from Estonia, what is the role of the court? We cannot allow agents to be the ones making decisions about data of private individuals. The court is the final arbiter, and the bill must come out very clearly on the role of the courts when questions around data access or processing are concerned. We must reiterate that the court must be the final arbiter when these questions come, so that it is not myself as an agent to determine whether national security is at stake or there is a public interest to reveal masses number, or what can we allow the institutions which have been established by the people of Kenya to conduct their functions. And therefore, I think my considered submission, clause 3 and clause 6 are actually bad law and should be repealed from this bill. Thank you.
Let's narrow the limitation clause to only apply to Article 31C. The right to privacy is wide. It's under right of privacy where we find also things like searching someone's home, searching their person. That's not data protection. But if you have a general clause here that says Article 31 is limited to the following circumstances, now we end up going into those superfluous exceptions. You know, if you've committed a crime, then I can search you. So the limitation clause should only address Article 31C, since it's the bedrock of the data protection in the right to privacy.
Great, thank you very much. Okay.
Thank you for this opportunity. I represent Kenya Cyber Security Association, and kindly allow me to share my contribution on the same. If we take a case scenario of like this hotel, when you come in, let's say as a guest, they record your information. That is the basic information, like your email and your name and all that. As per this bill, this being a hotel, probably they are using technology to do that. How are they, as a data collector, how are they supposed to comply to this bill? For instance, there are requirements for them to be tested, maybe some security assessment to show that they have really complied to this specific bill. But coming back to the issue of standards, which standards are we going to adopt? Because there are different standards, like pen test standards, there are those HIPAA for the health, PCI, DSS. Are we going to come up as a country with our own local standards? And which body is going to champion for this? Or are we going to adopt some international standards such that when those IT professionals, the cyber security professionals, when they come to this hotel, because we had this issue during the GDPR awareness, you could go to a hotel and then they ask you, how are we supposed to comply? Are we supposed to have some certificate? And where are we going to get this certificate? Probably we could tell them that you are supposed to undergo some security assessment, showcase that someone has maybe tested your internal technology systems and all that. So that needs to come out very clear. The other one is on there are those providers who do not necessarily hold the data in their, let's say, in their environment. Where are they in this whole ecosystem? What is their responsibility? They don't hold data at any point. The data is always on transit, maybe through their network or through their systems and all that. The other one is the right to be forgotten. What measure is going to be put such that we make sure that my data has really been forgotten? For instance, is the data going to be deleted or is data going to be shredded? Because if you delete the data, it's possible to extract the same information using some forensic methodologies and all that. And last thread is also the issue of notification to the data subject. But there's an exception whereby my data can be collected without my consent. So it also contradicts itself, also bringing the issue of national security. Let us not lie to ourselves. The government collects our data without even our consent, and that will not change because we are having a new bill. So that needs to come out very clearly that at what point is there an exception that me as the data subject, my data can be taken without my consent. Thank you so much for your...
Thank you very much, and we are very, very impressed with the quality of submissions and, and the passion with which you have provided us with very detailed information on what needs to change and how we're going to improve this. I have no doubt in my mind that really with all these submissions we're going to have a really progressive bill, so to speak. Now, again, this is not finished. We're very keen on having everybody's input into this bill. So tomorrow, again, we have now the wider public, not just you experts. Now, again, those are your clients as well, so it'd be nice for you to also hear what they have to say. So please, you're most welcome again tomorrow to County Hall, just so that you're part of this all the way, from 9:30 to 11:30 a.m. tomorrow at County Hall. Additionally, some of these discussions are just amazing. We need to have all this in writing. I know a lot of you have given us very detailed submissions, but those of you that haven't, please give us this very important input in writing, and in the memos kindly indicate possible amendments or introductions of new clauses. This is still open for making it better. Now, the bill, just to take you through some of the steps that the bill is going to go through from here. Of course, tomorrow we continue with this, a bit with more broad constituencies. The bill was read, of course, as you were told by our chairman, on the 3rd of July for the first reading, which is basically just an introduction. This bill is going to be introduced to the House. It was committed, of course, to this committee, and normally then, as per our standing orders, this is one of the public participation days. We have 30 days to pass on to this standing order to conclude this. The committee will then collate and consider every submission that you have made to us today and make sure that it's then given back to you for reviewing as a feedback mechanism. Did we really incorporate these things? Then we will compile a report with the possible amendments and table it for consideration in the floor of the Senate. And then, of course, after passing of it proceeds to the National Assembly for them to then counter-check. I know some of you have mentioned to me that the executive has also another bill. We will continue with this, and at some point, of course, we will always see how things can be harmonized. But because this process has gone so far already, we will continue and we will produce the best document we can as we go along in the interest of time and in the interest of making sure that we take advantage of the opportunities that this bill is going to bring for us, as opposed to then just waiting and letting opportunities bypass us. So with those few remarks, I don't know if maybe I should give my colleagues to say something.
Make a contribution to this bill. I think this is not the end of it. Make a contribution to this bill so that at the end of the day, the final bill that we will pass, if we will, is something that we are all proud that we made a contribution to. Lastly, to just say, whenever we seek your participation in future engagements, in future bills, I would encourage that we really take it up. And let's do that which we can do at this time, because we are here to do these things. Asante, God bless you.
Okay, thank you very much. First of all, let me thank this chance also to really thank the stakeholders for really finding time to attend this very special meeting. Indeed, we've really interacted well, and the contributions that you made will by no means go a long way in really enriching this particular bill. I wish to say that in future, don't shy away. If you even feel like you want to bring other bills that are related to ICT, you're free. And in any case, you can even invite us. We've invited you today, but then you can also take a chance and invite us, bring other bills away from that bill that can affect this work in the data world. I'm sure when you talk about data and data use and protection, it is unnecessary, more particularly when you are talking about protection as well as is in jeopardy. And in any case, there could be war, and if there is war, of course, the leadership in the country has got the power even to shut every media house to say so. I'm sure even in future, if a war to break out, I think another contributor has already talked about a case where there is some sickness that has broken out, that is of course going to bring some ill health to a mass group of people in the country. Of course, somebody should take authority over that and ensure that they make use of whatever means to ensure that there is protection of the people. Otherwise, as it has been stated, this bill is still at the early stages of formation, and you're still welcome tomorrow, and continue to give us inputs. We in the Senate are very open, as has been stated. We are not lawyers ourselves. We are open to stakeholders, and that is the reason why we are sitting here today, to really make sure that the bill that shall go out there to the people is a bill that is well formed, well edited, and well written, or in this case, is the best. Otherwise, thank you very much. May God bless all of you. And in this case, welcome for lunch. Thank you. God bless.